Will come to order. Messages from the Senate.
Message from the Senate, and this is the Kresha motion. Mr. Speaker, I hereby announce the passage by the Senate of the following House file, herewith returned as amended by the Senate, in which amendments and concurrence of the House is respectfully requested. House File Number 1702, an act relating to juvenile justice. The message is signed Cal R. Ludeman, Secretary of the Senate. Kresha moves that the House concur in the Senate amendments to House File Number 1702 and that the bill be repassed as amended by the Senate.
I recognize the member from Morrison, Representative Kresha, to discuss the Senate amendments.
Thank you, Mr. Speaker, and I do move that we concur even though they were incorrect and taking a hyphen out, and I could go on and on and on, but we'll just go ahead and move forward. So,
any discussion on the Senate amendments? Seeing no further discussion, all those in favor of the motion to concur with the Senate amendments say aye. Aye. Those opposed say nay. The motion prevails, and the clerk will give the bill its third reading as amended by Senate.
Third reading, House File Number 1702, as amended by the Senate.
Third reading. Any further discussion?
Yes.
The member from Ramsey, Representative Moran.
Thank you, Mr. Speaker. Representative Kresha rise for a question.
He will yield. Representative Moran.
Representative Kresha, this bill went through, I think, civil law and public safety. Can you run through what it does?
The member from Morrison, Representative Kresha.
thank you, Representative Moran. So if you remember, this was the bill that we passed, I believe, a couple weeks ago that we titled Ashley's Law. And what this bill does is it makes sure that kids that turn 10 years old or are 10 years older in the child protection out of placement system, that they are notified that they have right to counsel. And this makes sure that happens with social workers. So essentially what we're doing is we're just making sure these kids know that they have legal counsel, which is already in law. Excuse me, Mr. Speaker.
Representative Kresha.
I'm sorry, I meant McKenna's Law. I think I said the wrong name.
Representative Moran.
Thank you, Mr. Speaker. So will Representative Kresha stand for another question,
He will
please?
yield. Representative Moran.
So I believe currently in law that any child that go into child protection is supposed to have a court-appointed attorney. And so I'm just trying to better understand, you know, they should have a court-appointed attorney. But sometimes the barrier to that may be, and I don't know what a 10-year-old would do with that information, right? Because sometimes adults don't even know what to do with that representation. You know, and so I'm just trying to better understand that even if a social worker tells them that they can have a court-appointed attorney, which they should automatically have a court-appointed attorney, what is the barrier from that happening?
Representative Kresha.
Thank you, Mr. Speaker, and thank you, Representative Moran. So the reason we passed this law was because some kids weren't being told. And whether the guardian ad litem may not be telling them or thinking in their best interest that they shouldn't be appointed, that information wasn't getting there. So we need to first make sure that these kids have the information. Now, there may be barriers, there shouldn't be barriers, that these would be costs that would be passed on to the counties, or if the costs were to increase, and we may have to look at that. But at the end of the day, these children are entitled to know they have legal counsel, and that they should be fully informed before they waive that, and waiving of those rights should be done in writing.
Representative Moran.
Thank you, Mr. Speaker. So I'm a little confused because I don't understand how a kid's right can be waived and not get a court-appointed attorney, and they are a child, and by law they should have a court-appointed attorney. And so I'm just getting a little confused about this system that we have that is that children are not having, that they don't have the representation that they need, that they are supposed to have in law. And so with this bill that you're moving to have maybe a social worker or a guardian ad litem or someone say to that child, you have a right to a court-appointed attorney, which they should have that anyway. And so how can we get access? Is there an issue of, along with this policy piece, is there not enough public defenders or attorneys to represent the young people? Why are they not getting the representation that they should have, that they need to have within our court systems?
Representative Moran, are you asking him to yield?
Yes, please.
He will yield. Representative Kresha.
So what we don't know is how many kids are not getting attorneys. We do know that every kid that turns 10 years old or is 10 years or older is entitled to that representation. That we do know. What we found out through this process was even though they were supposed to be informed by a guardian ad litem or they were supposed to be informed by the judicial system that they had the right to legal counsel, that wasn't happening. So this law tries to close that loophole up a little bit or close that information gap to make sure that if you're a kid that turns 10 years old in an out-of-home placement, that you have access to an attorney. The story that you heard from McKenna was she was never told that in her county. And she was fighting for her rights. She was fighting for the judge to listen to her, to not have to go back to her home, but the system that was happening there kept trying to do unification. She was fighting the other way. Once she got an attorney, and once her grandmother, her step-grandmother was able to help, and they were able to get counsel on their own, they had to fight this. Even though they had the right to counsel, they were able to make some headway. Now, what this bill does that we're concurring to and sending to the governor, hopefully closes that gap so these kids have the knowledge that they have counsel. Now, once they know about the counsel, what we don't know is this going to create a need for 100 representation? Is it going to be 500? That we're going to have to deal with after this becomes in effect and we start to see how many more kids finally are getting the representation they need. And I fully expect that I will be back here asking if we need additional funds, because it's my belief, yes, as I think you've stated, Representative Moran, every kid needs to have an attorney. I've always believed that every kid that is in the out-of-home placement needs to have an objective third-party representation to help them navigate a very complicated system. I hope that helps. And I see Representative Hillstrom is up, so I'm actually going to yield to her if she can help me with the finer points.
You can't yield to her, but I can call on her. The member from Hennepin, Representative Hillstrom.
Thank you, Mr. Speaker and members. Members, this is the first step of a whole lot of work that needs to be done in the child protection area. This bill requires that a child be informed and that they can only waive their right to counsel in writing. And the court is the only one that has to say, I know, that child knows that they have the right and that they are waiving it. Previously, parents would waive that child's right to counsel or someone else. Or the court would not see the child in that first court appearance and not even know that the child didn't have a lawyer necessarily appointed. So members, public defenders are the ones that are supposed to represent children that are over the age of 10 that are in the system. And right now in the Public Safety Omnibus Bill, they had requested 38 additional public defenders to deal with the caseload that they currently have. That was not granted, and the funding that was placed in that bill would actually result in 40 to 50 public defenders being laid off. So while this bill today is the right thing to do, we also have to match the resources to actually do the right thing. Currently, the guardian ad litems are supposed to tell the court what's in the best interest of the child. The child's lawyer is supposed to tell the court what the child wants. Because ultimately the best outcomes happen when the court knows both what's in the best interest of the child and what the child would like that outcome to be. So members, this is the first step of a lot of work that needs to be done in this area to make sure that our children who end up in this system are not left behind.
The member from Anoka, Representative Whalen.
Thank you, Mr. Speaker, and thank you, Representative Kresha and Representative Hillstrom, for your comments. Representative Kresha, you and I have spoken about this bill, and I'm just so thankful for the work you've done on it and for carrying it, and for so many members in this body who've worked on this issue. I completely agree this system is broken. Very concerned. McKenna's story was so heart-wrenching, and I'm thankful that we're taking action. But I just wanted to echo a couple of things that Representative Scott mentioned a while back about, and then Representative Hillstrom said again about this being a first step. And I'm concerned about some potential unintended consequences when we are talking about attorneys presenting what the child wants. And so just wanting to continue the conversation and say that this is a really good step. We want to protect children. We want to do everything we can for them. But to think really seriously about attorneys, children, parental rights, and all of that. And specifically just that if we have guardian ad litems, the system as it is right now representing the best interest of the child, that specifically being broken, that being very clear in testimony that that system is broken, and taking a really hard look at that. So I'm voting for the bill, I'm supporting the bill, and I'm thankful for your work, but really looking forward to continuing the conversation.
Seeing no further discussion, I apologize, Representative Moran. The member from Ramsey, Representative Moran.
Thank you, Mr. Speaker. So, Representative Kresha, I believe it's a good bill, right? And it is the right thing to do because we always want to have the best interest of the child at the forefront. You know, and so I just brought it up because this is something we should be doing. We should be protecting our kids. And their voices should be going into that courtroom, and it's not happening. And so it concerns me when we do something that's nice, that we already should be doing, that whether or not this is going to have the impact that we hope it should do, right? And we have to put some dollars with this. It's a good gesture. That's the way I see it. It's a good gesture. But unless we have enough court-appointed attorneys to represent young people, they will continue to not have that representation, whether they know it or not, or even know what to do with that, or what that means. So my hope is that as we move forward, that we do move forward on the best interests of kids who are being put in out-of-home placement, so that they have representation, and that they will have an attorney to represent their voices within the system. So thank you. And I do have some concerns to unintended consequences too. Thank you.
The member from Morrison, Representative Kresha.
Thank you, Mr. Speaker. Members, the problem was the kids did not know. And everything I've heard, I'm all for additional resources, and we're going to have to get there. But at the end of the day, kids did not know they had legal counsel. That's important. Let's take that first step. And the second thing, and I appreciate the comments that are made, I've heard this a couple times, and I will say this publicly every day, twice on Sundays. It's not that the system is broken. The system is overburdened and overtaxed, and we're putting too many kids through this system because of things that are happening in the homes. Let's be clear about what is happening with our system. It is overburdened because it's a responsive system to parents and home lives that are very difficult and putting kids in a tough situation. But at the end of the day, when I researched this bill and I talked to guardian ad litems and I talked to legal counsels and county attorneys, people were passing the buck and afraid to tell the kids they had access to legal counsel. If you, as a 10-year-old child, have been beaten and neglected, you probably have seen more in your life than the adults that are trying to tell you what's good for you. And I think they can handle the legal counsel. So let's just tell them that they are entitled to that, get them that objective attorney, and we'll deal with the funding as we find out how this comes down the road. But members, don't mistake, I appreciate it. It's not a glossed over. This is not just a nice bill that we sign. This is making sure that kids have the rights they're entitled to. And I think that's a big step. Please vote for the bill, members.
Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 121 Lesh votes aye. There being 122 ayes and 0 nays, the bill is repassed as amended by Senate and its title agreed to. Recognize the member from Carlton, Representative Sundin. For what purpose do you rise?
Thank you, Mr. Speaker. I rise for a point of personal privilege.
State your point of personal privilege.
Thank you, Mr. Speaker and members. Today in the gallery we have an instructor, Carrie Gallagher, and a graduating class of apprentices from the International Union of Painters and Allied Trades. Some of these fine young women and men have exercised their crafts on the renovation of our capital. Please join me in thanking them and congratulating them on their graduation.
Messages from the Senate.
Message from the Senate. This is the Jessup motion. Mr. Speaker, I hereby announce the passage by the Senate of the following House file herewith returned as amended by the Senate, in which amendments to concurrence of the House is respectfully requested. House file number 2174, an act relating to local government. The message is signed Cal R. Ludeman, Secretary of the Senate. Jessup moves that the House concur in the Senate amendments to House file number 2174 and that the bill be repassed as amended by the Senate.
I recognize the member from Ramsey, Representative Jessup, to explain the Senate amendments.
Thank you, Mr. Speaker. Thank you, members. The revision with the Senate is very brief. Instead of revisions to 2 subdivisions, the Senate version removes a revision to 1 subdivision of the section and just puts it to 1 subdivision completely. What that does is it adds 1 line. At the very end of subdivision 7, the recommendation is any position filled pursuant to this subdivision is exempt from the requirements of subdivision 1. Very minor change.
Any discussion on the Senate amendments? Hearing no discussion, all those in favor of the motion to concur with the Senate amendments say aye. Aye. Those opposed, no. The motion prevails, and the clerk will give the bill its 3rd reading as amended by Senate.
3rd reading, House file number 2174, as amended by the Senate.
3rd reading as amended by Senate. Any further discussion? Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 122 ayes and 0 nays, the bill is repassed as amended by Senate and its title agreed to. Messages from the Senate.
Message from the Senate. Mr. Speaker, I hereby announce the passage by the Senate of the following Senate file herewith transmitted. Senate file number 550, an act relating to natural resources. The message is signed Cal R. Ludeman, Secretary of the Senate.
First reading of Senate files.
First reading, Senate file number 550, an act relating to natural resources. Heinzelman moved that Senate file number 550 and House file number 1265, now on the general register, be referred to the chief clerk for comparison.
Hearing no objection, so ordered. Calendar for the day. The first bill on the calendar for the day is House File 399. The clerk will report the bill.
House file number 399, number 1 on the calendar for the day, an act relating to public employment, the first engrossment.
I recognize the member from Hennepin, Representative Anderson S., to introduce your bill.
Thank you, Mr. Speaker. Members, this is dealing with the severance packages that were released back in September. There was an article about it. This just addresses the issue to make sure that the language is as the legislature intended it. And that's it in a nutshell, and I stand for any questions.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File Number 399.
Third reading. Discussion on House File 399. Seeing no discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 102 ayes and 20 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 470. The clerk will report the bill.
House File Number 470, number 2 on the calendar for the day, an act relating to public safety, the first engrossment.
Recognize the member from Isanti, Representative Johnson B., to introduce the bill.
Members, Mr. Speaker, this is a bill dealing with emergency vehicles, fire trucks, ambulances, and squad cars that are intentionally damaged by people taking them out of service. Mr. Speaker, there is an amendment for this bill. If we could take that up.
Representative Johnson has an amendment at the desk. The clerk will report the amendment.
Johnson B. moves to amend House File Number 470, the first engrossment as follows, and the amendment is coded DE1.
I recognize the member from Isanti, Representative Johnson, to introduce the amendment.
Mr. Speaker, members, this amendment cleans up the bill quite a bit. It keeps criminal damage to property instead of a second section for law enforcement or for emergency vehicles, puts it into the criminal damage to property section dealing with first degree and third degree damage to property. This bill, I can relate very much to this bill. Back when I first started my career in law enforcement, I was at a complaint. I was a theft complaint. When I left the residence, went walking back to my squad car, which was parked on the street, and at the time the city of Bremen only had one squad car. I got a call of an accident and possible an accident with injuries. So I had to run to my squad car to jump in, started it up, turned on the headlights, and I couldn't see out the windshield. Somebody had painted the windshield black. My squad car was out of service. I didn't have another one. The deputy finally was also responding to the accident, got there first, and thankfully there were no injuries. But I had to drive with my head out the window at night to the shop and spend an hour cleaning the windshield so we could get the vehicle in service again. Otherwise, the city would have been without a squad car until the windshield could have been replaced. So that could have caused a lot of emergency and could have caused the life of somebody had I not been able to respond with our vehicle. So it's important that we get this taken care of and make sure that the people do not damage or intentionally damage these vehicles with vandalism or damage the property. And with that, I'm available for any questions.
The member from Hennepin, Representative Hillstrom.
Thank you, Mr. Speaker and members. I would encourage you to support the DE amendment. Members, this narrows the bill. The bill was much broader when it was first introduced, and this makes it very specific that it's about damaging the vehicle and in its attempt to keep it from doing its serious business in responding to calls, and I encourage your support.
Any further discussion on the DE1 amendment? Seeing no further discussion, all those in favor of adoption of the DE1 amendment signify by saying aye. Those opposed, no. The motion prevails and the amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File Number 470, as amended.
Third reading. Discussion on House File 470 as amended. Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 120 ayes and 2 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 1001. The clerk will report the bill.
House File Number 1001, number 4 on the calendar for the day, an act relating to administrative rulemaking.
The member from Scott, Representative Vogel, to introduce your bill.
Thank you, Mr. Speaker. Members, House File 1001 requires a notice to be delivered to the legislature when an agency is preparing new rules which would add more than $1,000 per unit to the cost of residential construction. It puts in place a process before such rules are approved for implementation and permits but does not obligate the legislature to require an objectionable rule to be approved by law before taking effect. The bill provides a procedure in which the agency proposing a rule must make a determination before the close of the hearing period as to whether the rule will add more than $1,000 to the cost of a residential construction unit. The determination of the $1,000 threshold is made by the agency but is subject to review by the administrative law judge. If it is determined that the proposed rule has a cost in excess of $1,000, notice must be then given to the chair and the ranking minority members of the policy committee of both houses with jurisdiction over the budget matter of the proposed rule. If a committee votes to advise the agency that the rule should not be adopted as proposed, the rule cannot be adopted unless approved by a law enacted after the vote of the committee not to adopt it. The rationale for this bill is to help ensure that the potential for homeownership is not further eroded because people, especially those of lower income and who have limited down payment resources, are further moved out of the marketplace by homes they cannot afford. Studies have shown that 45% of U.S. households are priced out of the market when homes cost above $175,000, and that over 60% are now priced out when they cost more than $250,000. The studies also show that for every $1,000 in price increase, approximately 4,000 additional people are priced out of the marketplace. Although there are many reasons for price increases in housing, it's important to know that it's now estimated between the development of the lot and the cost of construction of the home, approximately 25% of the cost of a new home can be attributed to some form of regulation, rules, or fees by governmental or regulatory agencies. For this reason, it is important that we as a legislature do what we can to help control the cost increases for which the state is responsible. It's also important to remember that those most affected by this affordability crisis are people who are least able to overcome it. That's because first-time homeowners and lower-income home buyers have more limited resources, and because the incremental cost attributed to regulation on less expensive homes is a far greater percentage of the cost of that home than it is in the case of higher-priced homes. I ask for your support on the bill so all people, whether they have significant resources or are just starting out and want to get into their first home, have a chance to enjoy the benefits of home ownership. Thank you.
Representative Vogel offers the following amendment. The clerk will report the amendment.
Vogel moves to amend House File Number 10,001 as follows, and the amendment is coded A4.
I recognize the member from Scott, Representative Vogel, to introduce the amendment.
Thank you, Mr. Speaker. The A4 amendment was arrived up after some testimony in committee by subcontractors who wanted a little more clarification on some of the details within the bill. I move its adoption.
Any discussion on the A4 amendment? The member from Ramsey, Representative Mahoney.
Thank you, Mr. Speaker. Would Representative Vogel yield to a question?
He will yield. Representative Mahoney.
Representative Vogel, can you cite some offsetting savings that might be achieved through this?
The member from Scott, Representative Vogel.
Mr. Speaker and Representative, actually that is in the A3. The A4 that we're on is the one that deals with the correction language.
Any discussion on the A4 amendment? Seeing no discussion, all those in favor of adoption of the A4 amendment signify by saying aye. Those opposed, no. The motion prevails and the amendment is adopted. Representative Vogel offers the A3 amendment. The clerk will report the amendment.
Vogel moves to amend House File Number 10,001 as amended as follows, and the amendment is coded A3.
The member from Scott, Representative Vogel, to the amendment.
Thank you, Mr. Speaker and members. The A3 is intended to allow agencies to work better together. Part of the testimony, there wasn't really a lot of conversation going on between different agencies and even within departments such as Department of Labor and Industry as to how regulations were affecting each other. So what the A3 does is it allows either interagency or other agencies to work together to bring the cost of proposed regulations below that $1,000 threshold. Doing two things. First of all, it might avoid the need for implementing the $1,000 notification. But secondly, the hope is that we'll have the agencies working closer together to look at existing regulation to see indeed if they can be redone or maybe minimized so that as new regulations are done, we won't have the need necessarily for the old ones, and we can minimize the cost, again, looking out to protect the homeowner and allowing more affordability.
The member from Ramsey, Representative Mahoney.
Thank you, Mr. Speaker. And would Representative Vogel yield to
He will
question?
yield. Representative Mahoney.
I suppose I could have asked these to your bill, and I probably will again. But could you, for the body and for me particularly, give me a clearer picture of what you mean by calculating the cost of implementing?
Representative Vogel.
Thank you, Mr. Speaker. Representative. Well, calculating cost is already supposed to be done because the existing statute says that the cost of new regulations is supposed to be taken into account before they're put in place in the first place. So I guess as far as determining the cost of the regulation, I would defer to the agencies that are already supposed to be doing it and the methodology that they're using.
The member from Ramsey, Representative Mahoney.
Thank you, Mr. Speaker. And will Representative Vogel continue?
He will
to
yield. Representative Mahoney.
So, Representative Vogel, when they're calculating the cost, and frankly, I have read most of the code legislation and statutes. I still remember about 12, 15 years ago when Representative Krinky and I had a long fight on the floor over a rewriting of those. So I don't remember that particular piece, and our statute books are only about 15 or 16 books, and I don't read them all. but I'm trying to figure out how you calculate cost and then how you are saying what you want to put into this when they calculate the cost. Codes are built and written on safety, and it's particularly life safety. That's where they go. You go to all the IATMO and ICC and everything else. They're based on health and safety. So when we go to calculate the cost, and if it's a reasonable cost, are you expecting them to calculate in the cost of a life or the cost of health in this particular calculation? Or are you just going on what they have been doing for the last 12 or 15, well, actually about 100 years?
The member from Scott, Representative Vogel.
Thank you, Mr. Speaker and Representative. You know, I can't speak from experience, having not been an employee of the agency putting these things together. I do know from other parts of the statute that they're supposed to recognize the cost, so I would imagine each agency may have its own cost methodology that they're using to put this together. This bill looks at not just health and safety, but it also looks at a lot of other things. There's quite a bit of cost being driven, not just necessarily with even health and safety, but whether it's energy standards or insulation methods or different things that have to be done throughout the code. So it would be hard for me to tell you exactly what I think the agencies are doing in particular. I just know that they're now responsible for making sure that the cost is supposed to be adequate or is supposed to be offset relative to the severity of the regulation that's being put in place.
Representative Mahoney.
Well, thank you, Mr. Speaker and Representative Vogel. I won't belabor your particular amendment. I'm going to belabor your bill. I just have one other question, if the Representative Vogel will yield.
He will yield. Representative Mahoney.
On this amendment, or your previous amendment, or your bill, did you have a conversation with the Department of Labor and Industry and their Code and Safety Division before you entered it? Did they give you any feedback on your particular proposal? And if so, could you share it with the body?
Representative from Scott, Representative Vogel.
Thank you, Mr. Speaker and Representative. The bill went through the hearing process, and yes, the Department of Labor and Industry did testify. In fact, the A4 was driven by the testimony that came up in committee to put some language in effect that made it more definitive. I recognize that I did get a letter from a code agency saying that they didn't really appreciate the bill, but the bill itself is intended to look at the cost of home ownership, especially, like I said, relative to lower income people and people that don't have large down payments, because this has been a cumulative effect in people trying to get into their first home, especially with things like Dodd-Frank and so forth that are making the qualifications harder. So it's been much more difficult for people, especially, like I said, of lower income and lower means to get into homes. And now with the cost of regulation and fees and so forth approaching 25% of that home, my feeling is anything the legislature can do to help people be able to afford their first home, get into that first home so they can build some equity, is certainly a desirable thing.
Representative Mahoney.
Thank you, Mr. Speaker and Representative Vogel. That was a good example of how to defer a question. I'm going to take from your answer, because you didn't answer my question, that you did not have a conversation with the Department of Labor and Industry and the Division of Inspection. As I heard you, there was brief testimony, I know, in our committee, and they sent you a letter. Would the would Representative Vogel yield for a question?
He will yield. Representative Mahoney.
So as I paraphrased your answer, it is no, I got a letter and I listened to brief testimony. Is that correct, or yes or no?
The member from Scott, Representative Vogel.
Thank you, Mr. Speaker and Representative. Quite honestly, I can't remember whether or not I had somebody specifically in my office for Department of Labor and Industry on this particular issue. I know in the past some of the things that I have done, such as the sprinkler issue, I have. Unfortunately, with session going on, I can't remember if I had somebody in my office or not.
The member from Stearns, Representative Tice.
Thank you, Mr. Speaker. As somebody who has participated in the process, I know that sometimes theory is different than the practical use. And a lot of times when these codes are put in place, there's a lot of discussion about how much they do cost. And some of the builders will come up with what they expect this will cost, and they're not the same as what we're hearing from the Department of Labor. One case in point is the bill that I carried earlier was twin homes. The purpose of twin homes is to be a low-cost way to get folks in homes, whether they be first-time homeowners or they be retired folks. And the cost of the sprinklers were causing a problem in that the permits were going down, that people weren't building these things. And so when we put twin homes back to where they should be, into residential, we're hoping that it'll absolutely change it around. But we see a lot of examples like that. A lot of times when the code comes out and the costs are available, we're hearing from the department folks that, oh no, it's not going to cost that much. But guess what? Most of the time it does. But they don't take a look at some of our numbers and what we have to go through. When the last code came out, there were a lot of changes that really made a difference to the home, like heating alone on a house could go up $7,000. But guess what? None of that is shared with appraisers. So when a couple goes to close on their home costs are more, basic home costs, I'm not talking about anything, but the direct costs are more than what the appraisals will show up because they don't reflect that into their appraisals. They don't go back and forth. They're not shared. And some of these things just don't make sense. They create extra work if you want to remodel later. Some of it is putting sheetrock in a crawl space. So if you want to finish a basement ceiling, if you want to go back and remodel, you have to take all this down again and redo the whole thing. So there's a lot of times when we look at what's happening, we don't look at the total cost. We don't look at what happens in a couple years if they want to finish their basement or something like that. There's a lot of instances where the builders and remodelers have said, hey, this is a lot more than what you're saying it is. And there hasn't been anything. And I won't even get started on the cost it would be to put a sprinkler system into a home in a rural area with their own septic system. It's just, there's a lot of variables that aren't taken into consideration. And what the building industry is saying is, hey, we have to be realistic about what these costs are and what we are doing to home building. Because we have been seeing that these costs are huge, and now the actual cost of a home is more than what an appraised value would be. So when we see the legislation such as Representative Vogel brings forward, it's really encouraging that maybe we can continue in the building homes affordably for all folks.
The member from Hennepin, Representative Dean R.
Thank you, Mr. Speaker. And will the representative yield to a question?
He will yield. Representative Dean.
So I'm going to try to stick to the amendment that is before us. I'll talk a little bit later on the bill. And the amendment says, page 1, line 16, after the period, insert, upon request of the party affected by the proposed rule. And you've spent a lot of time talking about the home buyer. So I would assume that we're talking about the home buyer, and then how is the home buyer going to actually respond to the agency's determination when they're not going to be buying the home, could be for 6 months, 2 years, whatever, into the future? Or do you want to redefine exactly what the party affected is?
The member from Scott, Representative Vogel.
Thank you, Mr. Speaker and Representative. I'm sorry, could you please repeat the portion that you're asking about?
Representative Dean.
Mr. Speaker, yes, Representative Vogel. If you look at your amendment 1.2, it says page 1, line 16, after the period, insert upon request of the party affected by the proposed rule. And this is speaking to the issue.
Representative Dean, we're on the A3 amendment.
Oh, my bad. I'm sorry.
The member from Hennepin, Representative Hertas.
Thank you, Mr. Speaker and members. Well, this is an interesting discussion, and I just wanted to comment about really the intrusive and pervasive nature of government really driving the price of housing. And it really is a complicated issue because there's both direct and indirect costs that are inputs into housing. And in the very basic form, it starts at the regulatory process of even just getting lots to be developed and platted. And a state law like this isn't going to reach and touch into some of those local communities, but you've got communities who refuse to use land efficiently, where they're dictating the size of the lot, minimum development standards. You've got to have a certain type of light standard or light post in your streets. You've got to have sidewalks. You've got to have berms and extensive landscaping. And this all burdens the cost of the input cost of the lot in a home. So suddenly, even within the industry, and I've spent 30 years building hundreds of homes all across the metropolitan Twin City area. You have lots. I remember when I first started, I was building homes that retailed for $84,900 in Plymouth with city water, sewer, curb, and gutter. Now you can't even hope to buy a lot in Plymouth for less than $200,000, just the lot. And mortgage underwriting requirements require that not more than a fourth, maybe up to a third of the land value can account for the cost of a home. So you see how these things add up. And every time we have to build a better mousetrap on the part of government, whether it's having to have an air exchanger, or have more insulation, or you got to have this, or you got to have that, you've got to have a smoke detector in every room, you've got to have CO detector. All of this doesn't end with just the direct cost of putting that in there. You've got to pay your trades, your union plumbers and your electricians to install this stuff. And then on top of that, you have to pay sales commissions on the sale of the property. And no builder is going to do these things and not include a fair return on investment and the margin and the risk, because statutorily you have to warrant everything for 10 years. So when we talk about land use planning, even the intrusive manner in which a MPO like the Metropolitan Council dictates to these communities how they're going to grow, how they're going to develop, all of these things are driving the cost of housing. And so we've seen a typical median home significantly rise, clearly within my lifetime. I remember my wife and I bought our first home in St. Louis Park for $18,000. That wasn't that long ago. Now you'd be lucky to find one in the same community for under $200,000. So I realize there's inflation, but it's much more complicated than that. And we are, as government, making affordable housing unaffordable. And then we need more government to create affordable housing. So this is a problem that goes very deep and reaches into all sorts of different areas within the industry. And thank you, Rep. Vogel, for starting the dialogue and the process. There needs to be some curtailment of this, but it's just not going to end. Thank you.
Okay, any further discussion on the A3 amendment? Seeing no further discussion, all those in favor of adoption of the A3 amendment signify by saying aye. Those opposed, no. The motion prevails and the A3 amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File Number 1001 as amended.
Third reading. Discussion on House File 1001 as amended. The member from Ramsey, Representative Murphy E.
Thank you, Mr. Speaker and members, and I've been listening to the debate on the bill that Representative Vogel has before us today. Not so much for its content about housing, but for what I see as an ominous trend coming from your majority this session. In many of the bills that we have heard already this session, there is the provision of requiring the legislature approve either waivers or rules before they can become law, empowering this body further, taking more power to itself and by doing that, limiting the voice of the people in its own government. And there are many examples of that this session. And I am curious about the majority's intention about Minnesotans and their role in participating in our government when I think about your early effort to limit people's ability to peacefully protest their constitutional right and your decided effort to impair that. Your clear desire to preempt locally elected officials in their ability to pass ordinances for the people in their communities. The campaign finance provision that we saw the other night in Representative Anderson's bill that is nothing short of incumbent protection, limiting the ability for someone to challenge your safe seats, and escalating the power of special interests, the money being spent in our campaigns, once again limiting the voice of the people. And then again, throughout these pieces of legislation, giving yourselves, this legislator, your majority, the power to overturn rules that are properly promulgated with the voices of Minnesotans, with their interests. And then this week, we have watched with, I think, a fair amount of brazen attitude, your majority moving through this process bills that have not been properly heard in their conference committees. I think that Representative Hansen did a very fine job of showing to Minnesotans who are paying attention the unfortunate process that was used in wrapping up Representative Fabian's bill. I don't know why you have chosen to run roughshod over Minnesotans, and Representative Vogel, I don't know that that was your intention with this bill, but it is an absolute pattern that you are showing to Minnesotans that you are interested in using your legislative power to empower yourselves and your majority to protect not only your incumbency, but your majority going forward. It reminds me a lot of what I'm seeing in Washington, D.C. I think it is a terrible trend for Minnesota and for our time-honored openness in government. And I can't let this bill go by without calling it out. I don't think Minnesotans like their elected officials to spend their time empowering themselves. I think they're probably just as disappointed as I am to see you doing that today.
Okay, discussion on House File 1001. The member from Nicollet, Representative Johnson C.
Thank you, Mr. Speaker and members. I too see this pattern, and it actually extends beyond this session. I saw it last session where we're really trying to seek legislative approval of rulemaking. And in my mind, it just lays us vulnerable to politicize rulemaking. And it inserts politics where expertise has a lot more value, but it's also, to be honest with you, I'm concerned about the money in politics. There's a lot of money in politics. I personally don't like it. And I think this gives potential for inserting that money in politics and makes this legislature vulnerable to the influence by powerful and special interests in influencing this rulemaking. I don't think that's the way we want to govern ourselves. And when we're talking about things like safety and fundamental environmental regulations, we need to keep politics out of that. We need to make sure we're protecting the citizens of Minnesota. I encourage a no vote.
The member from Hennepin, Representative Dean R. To the House File 1001.
Yes, thank you, Mr. Speaker. And now that the A4 has been incorporated into that bill, I would ask if Representative Vogel would yield to a question.
He will yield. Representative Dean.
Representative Vogel, with the A4, we added the language that is relative to the administrative law judge and making a request for a proposed rule change. And I'm curious, when it says upon request of a party affected by the proposed rule, does that include the homeowner, the eventual purchaser of the house as well, or is it we really consider the party affected to be the builder that's going to earn the profits in the construction of the project?
The member from Scott, Representative Vogel.
Thank you, Mr. Speaker. Representative, that amendment was drafted by the subcontractors group that testified, and the language came directly from them. So in as much as it was from basically opposition in testimony, I was willing to insert the language that they had requested because they felt it was going to add more definition relative to this. So again, the language is an accommodation to those opposing the bill rather than the author himself.
Representative Dean.
Thank you, Mr. Speaker. So if I can summarize, Representative Vogel, this was brought by the subcontractors forward to assure that they would have a say in the process that currently they believe they may not have a say with your bill as currently proposed. Will you yield?
He will yield. Representative Vogel.
Thank you, Mr. Speaker. Representative, yes, it was brought by them to add clarity to the bill that I had drafted because they felt that if the bill was to become law, they would feel more comfortable in using the process relative to the provisions that they wanted to be able to address.
The member from Hennepin, Representative Dean.
Thank you, Representative Vogel. In a few more questions, if you would yield. Representative Vogel.
He will yield. Representative Dean.
So, Representative Vogel, you've spoken many times about lower income folks and that this bill makes it possible for them to enter home ownership. I'm going to make an assumption that you've done some research. Can you tell me the number of first-time home buyers that actually buy new housing that was recently built?
Representative Vogel.
Thank you, Mr. Speaker and Representative. I cannot tell you that number.
Representative Dean.
Thank you, Mr. Speaker and members. So I would assume that this is just something that we're going to say and we're not going to have any evidence to actually speak to it. And I want to respond to a couple other comments that members have made regarding this bill. We do need to look at total cost of home ownership. And energy costs is a huge component of that. And many of the provisions that have been added the past several years are about energy use, which ultimately has one of the most significant impact on low-income housing. So as we look at this bill is doing exactly the opposite. It's not making housing more affordable long-term. The goal is to try to make it a little bit more affordable now, and if you consider the impact of a $1,000 cost on a $200,000 house, which is below the median income for a house in the metropolitan area, it's really kind of insignificant. And to add to the comment of Representative Hertas, you know, when we talk about issues around sewer and water and curb and gutter, for all of you who have houses that have been around more than 30, 40 years in the metropolitan area, which is covered by the Met Council, part of your sewer bill and water bill pays for the expansion of those services on the edge. The developers that actually develop in that area don't pay the total cost. I think today, if we looked at the additional total cost of a piece of property at the edge where we're extending the sewer and water line in the metropolitan area, the added cost would be over $40,000 to $50,000 per lot. That's not what's charged to the developer. All of us that live in the metro area, part of our sewer and our water bill actually goes to subsidize that. So let's be clear about who's paying these costs. If Representative Vogel would yield to another question.
He will yield. Representative Dean.
Thank you, Mr. Speaker, and Representative Vogel. The current approval process of building codes from when they're actually proposed takes several years before we actually adopt them at the state. And sometimes they're adopted completely. Oftentimes we have exceptions because of the way we build in Minnesota versus other parts of the country. Do you know how much time your bill is going to get added to the approval process of new uniform building codes?
Representative Vogel.
Thank you, Mr. Speaker and Representative. Actually, I hope no more time gets added because right now the code says that the cost of the regulation is supposed to be taken into account before the rule is done. So if the agencies are already doing this, there shouldn't be any additional cost.
Representative Dean.
Thank you, Mr. Speaker. I think I was asking about additional time, and if we have a process in which we're allowing not only the people that are engaged in the current process of approving in approving these codes, which, you know, the building profession is involved in approving the codes. It's not just a bunch of bureaucrats over here in St. Paul that are looking at the codes and are saying, well, we think this is good, so we're going to do it, or we don't think this one is good, so we're not going to do that. The industry is involved in looking at those codes and reviewing those codes. And now we're going to have government at another process in which people can come and say, well, we're not sure about this and we think it's going to add another $1,000 to the cost. So we want to go before an administrative law judge to determine what that's going to do. And then you could even add that, you know, how is that going to affect the market moving forward? I actually think that this bill, although I really believe it might be intended to sort of make it easier. I think in the end it's going to make it harder. And that concerns me. And I would recommend that members vote no on this bill. Thank you.
The member from Ramsey, Representative Pinto.
Thank you, Mr. Speaker. Members, we've heard very good points from my colleagues about the bill more broadly, and I would commend you to look at the letter distributed by Representative Mahoney, but I want to focus on just a specific issue that has not been addressed, which is this mechanism whereby a legislative committee has veto power over a rule. I am not aware of any other example of that in our statutes and our rules. I've consulted with staff, so I wonder if my friend and colleague Representative Vogel would yield for a question.
He will yield. Representative Pinto.
Thank you, Mr. Speaker. So I guess, Representative Vogel, I'm wondering, I know that there's a provision whereby a committee can delay action by an agency until the end of the legislative session, but I'm not aware of any other example of this kind of veto power that's in this provision in this bill, and I'm wondering if you can cite any examples.
The member from Scott, Representative Vogel.
Thank you, Mr. Speaker and Representative. Actually, in reviewing 14-127, if you go down to subdivision 3, they talk about a business that has less than 50 employees having to file a cost estimate to make sure that it's not going to be harmful. And there's other references in that larger section that deal with the cost of doing the regulation relative to the benefit of the regulation. So we're not breaking new ground when it comes to saying that regulatory agencies are supposed to look at the cost of the regulation relative to the impact that it's going to have.
The member from Ramsey, Representative Pinto.
Thank you, Mr. Speaker. Representative Vogel and members, I guess that's not the point as agencies looking at costs and benefits, and I believe that is something that our agencies are doing very much. This is a provision, a bill that would not only require some additional review, but I guess the thing that Representative Vogel that seemed unprecedented to me is having a committee of this body have veto power. Representative Murphy talked about a number of ways in which it appears the legislature is stepping in and taking over control in certain areas, but we're not even talking about the full legislature. This is something where an individual committee has veto power. I don't see a reference to that in 14127 or any other provision. So if Representative Vogel would yield again, I would ask him if he can cite any example of that, a committee having that kind of veto power.
He will yield. Representative Vogel.
Thank you, Mr. Speaker and Representative. Well, the committee actually has veto power from the standpoint that they're going to make the law that is going to make the rule exist. So if you look at the origin of where any rule would come from, it is coming from the law that we're doing. So if the enacting body has a problem with the way the law is being enacted, my assumption is that anybody could come to the legislature and say, this isn't supposed to be done. Now, there's already a process in place for rule promulgation. All this is doing is saying you have to look at the cost of this rule in addition to everything else that you're supposed to be doing already.
Representative Pinto.
Thank you, Mr. Speaker. So I guess I won't belabor this any further then. I guess I am not aware, and it doesn't sound like Representative Vogel is aware either of any situation, any other situation, anything that we do whereby a specific committee of the legislature can step in and have the kind of veto power that is present in this bill. I believe that this raises some significant constitutional questions. Again, this is not the House and Senate acting. This is not the legislature acting. This is an individual committee. I believe that when this bill, I may be wrong about this, but when this was included in the state government omnibus bill, there actually was a constitutional severability clause added, basically recognizing that this does in fact raise constitutional concerns. I think for that reason alone, there's plenty of other substantive reasons, again, my colleagues have talked about, but this is in fact, let's be very clear, breaking very new ground unless somebody can point to a situation, and I haven't heard it from any place else. That alone is a reason to vote no. Let's make sure that we know what we're doing here. Thank you.
The member from Olmsted, Representative Liebling.
Thank you, Mr. Speaker and members. Well, my colleagues have addressed a lot of the same points that I originally wanted to speak to. I do believe that this bill violates the Minnesota Constitution. In Article 3, we have division of powers. And so what this bill is doing, just for anyone who's watching or listening to the debate, let's be really clear. This is taking something that, yes, the legislature passes law, the House passes it, the Senate passes it, and the governor has a participation in that too, and that gives authority to the administrative branch, to the executive branch, to do rulemaking. And yes, that's a grant that comes from the legislature and the governor. What this bill does is let one committee, not even the whole body, not even the whole of the House or the whole of the Senate, but one committee exercise power over a rule that is passed. And I do believe that that violates the separation of powers in the Constitution. So again, you constitutionalists, those who claim you are, you know, the problem here, and it is one that we've been seeing a lot of lately, and that is that Republican legislators seem to like limited government, except when it's a limitation of their own power. And that's what we're talking about here. You know, if you like limited government, then understand that the body that you participate in also has limitations. And it is up to us who took an oath to follow the Constitution of the United States and of this state. It is up to us to enforce those in the first instance, to know what it is and to act within our limited power. And this is a bill that most definitely violates, in my view, and maybe you won't believe me, and maybe some court will have to tell you later on, but this is a bill that really crosses the line when it comes to separation of powers. So we exercise our power here by passing bills. We have to conference those bills and agree with the other body that's going to pass a bill, and then the governor has to be involved too, and that is how we exercise our power. We do not exercise it through individual committees of this body, and that is what the bill does. It gives either a Senate committee or a House committee the power to veto a rule that was passed by the executive branch. So, members, I urge a no vote.
The member from Hennepin, Representative Nelson.
Thank you, Mr. Speaker. And members, this bill goes at regulations that are designed, that have been put into effect to protect the health and safety of people buying homes and living in homes. We used to build houses using balloon framing. Does anyone here, I bet you Representative Hertaus knows what balloon framing is, but we used to do it using balloon framing, where the studs went from the ground floor all the way up to the house, and there was these huge channels that would draw fire up if a fire started in the lower level and burn the houses down. And so it was required by the building codes that you put fire stops in. Putting fire stops in is going to cost more than $1,000 anyway, so you're raising the cost of the house. But you're affecting the life and the health and safety of the people that buy that house. And that's what most of these regulations, new regulations, are about, is the health and safety. Representative Hertaus pointed out exactly what the biggest problem right now is in building affordable housing, is you can't buy a lot cheap enough to make the house and build an affordable house, because the lot requirements that the cities put in on the lots, the lot sizes, you can't build a house and finance a house with the cost of the lot. So this isn't going to help make more affordable housing. And the other point I got to make here is that, I'm hearing this, and I keep saying this, it's going to help first-time home buyers. It's going to help poor people get into housing. So we want to allow substandard housing to be built and sold to poor people so that they can have a house. Why don't we just build tar paper shacks and say, that's the housing for the poor? Well, we don't do that anymore because nobody wants them in their neighborhoods. But that's what we're saying here. It's okay to build substandard housing. It's okay to put people that are poor into houses that are substandard and not have the health and safety regulations that are there to protect them. So members, this is a bad bill. Vote no.
The member from Ramsey, Representative Mahoney.
Okay, members, now you understand why we should not do codes on the House floor. Really, this is probably the worst thing we could ever, one of the worst things we could do. Because I have at least a dozen more questions. I can put a speech together on my feet, so I could talk for another half an hour on this particular issue. As I referenced earlier, 12 years ago, we moved all of this off the House floor. And ironically, and I was speaking earlier to one of the newer members, that if you stay around here long enough, you start to understand the word irony so well. Because it was the Builders Association that was very insistent upon the ICC code being put together and taking it out of the legislature. And I won't mention who was the person who worked that bill that particular year, but let me tell you, the Builders Association just taught me another lesson in irony. So again, I would certainly hope this is a lesson learned. I don't hand out many letters. I don't like to do that. I think we get enough paper, although I do understand the timber industry. But this is when I hand it out. There's one group of people that want this bill to pass. It's the Builders Association. But the appraisers, the inspectors, the construction people that actually put it together, the contractors that employ the construction people, on that letter, and the code creators, the ICC that we use, have all come out opposed to this particular bill. My fear with any piece of legislation, I'm getting old, but it's always the nose underneath the camel's nose underneath the tent. Representative Hertaus talked eloquently about the cost of land and how we do land zoning and everything else. And this bill really doesn't affect that, but that's the next step in order to get the cost of land down. We can, in this body, say that no municipality can create a land use program that requires more than a 1/4 acre. That would bring down the cost of a house dramatically. Because if you have a 2.5 acre lot, it's a lot more money. You know, we all want to get home. It's Friday. It's been a long, stressful week. We've sometimes sat here. So I'm going to finish up. I really do, Representative Vogel, have enough to tie you up in knots. You're a banker. You're not a construction guy. I get it. But I could tie you up in knots, and I'm going to be nice today. I made a resolution for this session to try to be as nice as I can be. But members, now this provision is in Representative Garofalo's jobs bill, Jobs, Energy, and some other alphabet soup committee. I believe it's in Representative Anderson's state gov bill. This is the third version, same wording, now with amendments. And the governor has objected to it multiple times through his commissioners. Letter after letter after letter cites this particular piece. So this bill, if it heads towards the governor's desk, is very likely to be looked upon poorly. So we're trying to get the governor to agree with us on issues, not disagree. I know that's a difficult deal, and I expect all three of you to come back from the fishing trip not wet. So, members, I would ask that you strongly consider voting this particular bill down for multiple reasons. Everything from the governor being unhappy with this, to it's the camel's nose underneath the tent, to the fact that we do not want to bring building code issues to the House floor and have a conversation that could last hours about the intricacies of balloon framing, or whether you really need a second gas valve on a furnace to make sure that the first gas valve, if it leaks, it doesn't leak, or how many GFIs you need in a kitchen, or whether you can use the 87-cent outlet or the $27 GFI. And this bill, just the last note on this bill, I don't understand how you can separate residential from commercial, because nowadays, quite often, we're building first floor commercial, second, third, fourth, and up, residential. It's a nice bill, written with good ink and everything else, but it's not quite ready for prime time, because you really do need to pull a whole lot more people together than just the Builders Association when you put a bill together on codes. Please vote no.
The member from Dakota, Representative May Quaid.
Thank you, Mr. Speaker. Members, when I'm 31, right, and when I talk to folks my age about being in the legislature, being in politics, people are like, why? No one who does that work knows our issues, cares. And I always say, no, they do. We talk about those issues on the floor. There are solutions coming from both sides that will help our generation. This is laughable. This is ridiculous. If I brought this bill, this piece of legislation, to anybody my age, to the 1/3 of millennials who are living in their parents' basement, and I said, millennials, I've got the solution. Any change over $1,000, we're gonna look at it. We fixed it. We're gonna get you into homes, because that's what it is, right? It's a $1,000 difference that's keeping you in your parents' basement, not getting you into homes. It wouldn't be the fact that you're paying 1/3 or 2/3 of your income to student debt, or that you have a kid and you can't afford childcare, or that you can't afford food, or that you had a broken ankle like in my family, so you had to move back in with your parents because of the medical debt. Come on. This is not a solution by any means for the affordable housing crisis that we have, for the crisis of getting millennials into homes for the first time. I was driving to work today, and I drove past 5 new developments that are being built in my community. And there's beautiful houses and there's beautiful signs that say starting in the low 390s. My God, if I only had $1,000 more, I'd totally be able to buy one of those homes, right? This is absolutely ridiculous, and now I understand why folks look at me and they say, what are you talking about? A solution for the affordable housing crisis? Seriously? Come on. This is a terrible bill. We should not be voting for it, and we should not be pretending like this is the solution to get millennials into homes. Vote no.
And for the final word, representative from Scott, Representative Vogel.
Thank you, Mr. Speaker, members. I recognized when I stood up here today that I probably wasn't going to have glorious acclamation of every green light on that board, but I felt it was necessary to bring this forward. I've dealt with homeowners most of my work life, and I've seen what's happened to people not being able to get into their home first. And with the increasing cost, I felt it was necessary to bring this forward. Is it something that I desire to be here doing? No. My hope is that the agencies in the first place would have been a little more accommodated of people's needs and not have maybe had so many regulations that are costing, but this is what we have to do. First of all, we have to remember too that we are not changing a rule. We are looking at a proposed rule, so this isn't changing a rule that's in effect. Secondly, this does not preclude any rules. All this says is that if there's rules that are going to add more than $1,000, they have to be, there's a process that can be used. Third, and I think very importantly, we've spent a lot of time talking about the government's needs and the efficiency of making these rules and getting them in place. We're here about the people's business. This is about the people trying to get into homes. And I think we have to make sure that we retain our focus on, yes, we don't want to make government agencies have to go out of their way and do things more costly than they need to, but we really need to spend attention to the people themselves, the people that are paying the cost. In reality, what we're looking at here is allowing people, hopefully, to be able to get into their first home. When Laura and I first bought a house, we bought a little house, we fixed it up, and it gave us the equity that allowed us to move into a larger house where we could raise our family. As we do this and we price people out of this marketplace, not only are we taking them out of new homes, but we're taking them out of existing homes that they can maybe fix up because they have to follow a bunch of regulations as well. So I'd ask for your green vote, recognizing that yes, it may inconvenience an agency a little bit, but if indeed we give people a chance to get into a house, to enjoy home ownership, to maybe move up into a different house if that's what they so choose, I think then we've done our business as a legislature. Thank you.
Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 73 ayes and 48 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 1725. The clerk will report the bill.
House File number 1725, number 6 on the calendar for the day, an act relating to motor vehicles.
Recognize the member from Wabasha, Representative Drazkowski, to introduce your bill.
Thank you, Mr. Speaker and members. This is the milk truck bill, and before I talk more detail about the bill, Mr. Speaker, I do have an amendment I'd like to add to the bill.
Representative Drazkowski offers the following amendment. The clerk will report the amendment.
Drazkowski moves to amend House File number 1725 as follows, and the amendment is coded A1.
Representative Drazkowski to the A1 amendment.
Thank you, Mr. Speaker. Members, the A1 amendment is an amendment that brings the bill in line with concerns and requests actually from the Department of Transportation. It corrects a technical oversight in the initial drafting of the bill that although I like the outcome of the technical oversight, it wasn't intended, and that is corrected in the bill, and it also removes Section 2 from the bill, which was a study that the department didn't want to be involved with. So I ask for your support on this amendment.
Any discussion on the A1 amendment? Seeing no discussion, all those in favor of adoption of the A1 amendment signify by saying aye. Those opposed, no. The motion prevails and the A1 amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File number 1725, as amended.
Third reading. The member from Wabasha, Representative Drazkowski, to the bill as amended.
Thank you, Mr. Speaker. First, the amended bill simply provides a 10% exemption for milk trucks throughout the state of Minnesota for single unit or straight trucks, as they're called. These are the smaller trucks that we find are needed to navigate the smaller dairy farms and the topographies upon which they're located. Very prevalent in southeastern Minnesota and other portions of the dairy belt that go throughout our state. So what this provides members is the ability for milk trucks, those straight trucks, to continue to operate the way they are now. It provides an exemption from 80,000 pounds to up to 88,000 pounds. I've handed out a handout, members, with details if you want to get into the details of this issue, but I will tell you, I have a map in front of me that looks at the surrounding states. For 6-axle vehicles in North Dakota, the exempted amount for vehicles like these is up to 105,000 pounds. South Dakota is 90,000 pounds. Nebraska, 90,000 pounds. I understand Wisconsin has a 90,000 pound exemption for milk trucks, and something similar as well in the state of Iowa. Members, ours is currently 80,000 pounds. We are becoming an island, and this has actually provided even that milk trucks that are attempting to haul milk across our state from one of these other states actually many times are finding a need to navigate around our state instead of driving through a portion of it. So I urge your support for the bill. Thank you, Mr. Speaker.
The member from Carlton, Representative Sundin.
Thank you, Mr. Speaker. Would the author yield for a question?
He will yield. Representative Sundin.
Thank you, Mr. Speaker. And Representative Drazkowski, I can empathize with the milk producers and the dairy farms in providing their product to the public because I did grow up on a dairy farm. I understand this issue quite well, and I also understand the truck weight limits. Increasing them can just compound the problems that we have with rural roads and bridges that are currently underfunded under the current transportation bill. I hope we can improve that before the week is done. But that said, I'm just wondering if we could reduce that 10% increase of the weight of the milk being hauled down to closer to like a 2%.
The member from Wabasha, Representative Drazkowski.
Thank you, Mr. Speaker, and thank you, Representative Sundin. Well, I'll have to contemplate that, Representative Sundin, but my observation has been that you really just skimmed through the bill, and it was really kind of a cheesy comment.
The member from Carlton, Representative Sundin.
Thank you, Mr. Speaker. I'd like to continue this conversation, but I'm feeling a little bit intolerant today.
Further discussion on House File 1725. The member from Nicollet, Representative Johnson C.
Thank you, Mr. Speaker. And Representative Drazkowski, there's some common sense to this bill, but not in the context of where we're at on transportation issues. I'm not surprised that the townships and the counties oppose this bill because that's where those milk trucks drive. As you know, they're on township roads and they're on county roads. And as I talked about the other day, townships really need about a $20 million increase a year in their funding to bring their roads up to scale where they can absorb this. So I'm frankly not ready for this bill today because we don't have that compromised, comprehensive transportation bill that would include constitutionally dedicated funding that our counties and our townships need to build their roads. But I remain hopeful. I'm an optimist. I hope we can get that bill. And I look forward to working with my colleagues on the other side of the aisle, the governor, to get a real comprehensive bill that is a compromise, the kind of compromise that Minnesotans are looking for. And I've been reflecting on this lately, and you know what? I think a really good president to the state of Minnesota would be early next week to set up the end of this session. Let's put together that compromise that I think is really obvious, that includes key elements for funding of roads from the governor's position and key elements for funding of roads from the legislature, and put together a real bill that makes sense for all of Minnesotans, and then include this language in that bill, and then I'll vote for it. Thank you very much.
The member from Hennepin, Representative Hornstein.
Thank you very much, Mr. Speaker. And I just wanted to reiterate the comments that Representative Johnson made regarding the opposition of townships and counties. Also, MnDOT expressed some concerns about this in both the Transportation Policy and Finance Committees. So let's get the transportation bill done, and then adequately fund our rural roads and bridges, and then maybe we can talk about truck weights. But today's not the day on that one.
Any further discussion on the bill? Seeing no further discussion, the clerk will take the roll on House File 1725. The clerk will close the roll. There being 75 ayes and 44 nays, the bill is passed as amended and its title agreed to. The member from Meeker, Representative Erdahl. For what purpose do you rise?
Point of personal privilege, Mr. Speaker.
I'm sure it's a quick one. Please state it.
It's really quick. In light of the last discussion, I just thought I would announce that Monday is Cheese Day, and there will be cheese in the retiring room.
The next bill on the calendar for the day is Senate File 1399. The clerk will report the bill.
Senate File number 1399, number 8 on the calendar for the day, an act relating to local government, the first engrossment.
Representative West, would you like us to take up the amendment immediately to insert the House language? Representative West offers the following amendment. The clerk will report the amendment.
West moves to amend Senate File number 1399, the first engrossment as follows, and the amendment is coded DEA 1519.
To the amendment to insert the House language, the member from Anoka, Representative West.
Thank you, Mr. Speaker and members. This amendment just reinserts the House language, which is how the deputy registrars would prefer the bill to exist.
Any discussion on the amendment to insert the House language? Seeing no discussion, all those in favor signify by saying aye. Those opposed, no. The motion prevails. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File number 1399, as amended.
Third reading. The member from Anoka, Representative West, to introduce your bill.
Thank you, Mr. Speaker. Members, Senate File 1399 is a bill that gives the license bureaus in Minnesota, the county license bureaus, the ability to set their own hours rather than having them prescribed specifically in statute. And I appreciate your support.
Any discussion on Senate File 1399 as amended? The member from Blue Earth, Representative Considine.
Thank you, Mr. Speaker. I am opposed to this bill, and I would urge others to vote no.
The member from Hennepin, Representative Hortman.
Thank you, Mr. Speaker. Members, I too oppose this bill. I think that we need to make sure that people can access
these services. And for some people who have difficult work schedules, this bill would make it more difficult for them to access these important county services. So I encourage a no vote.
Any further discussion on the bill? Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 69 ayes and 51 nays, the bill is passed as amended and its title agreed to. Report from the Committee on Rules and Legislative Administration.
Pepin from the Committee on Rules and Legislative Administration, pursuant to Rules 1.21 and 3.33, designates the following bills to be placed on the calendar for the day for Tuesday, May 16, 2017, and establishes a pre-filing requirement for amendments offered to the following bills. Senate file numbers 943 and 1456.
Motions and resolutions. There are copies of the non-controversial motions at the House desk and online. If there's no objection, we'll take action on these motions first. Hearing no objection, the motions prevail. The member from Hennepin, Representative Flanagan, for what purpose do you rise?
Point of personal privilege.
State your point of personal privilege.
Thank you, Mr. Speaker. So this week is the week of the family child care provider, and many of us know how important family child care is to folks throughout the state of Minnesota, and we just want to honor and recognize them. So I have a House resolution that I'm going to read. Whereas Minnesota has the second highest rate of working mothers in the nation, requiring quality child care that is both accessible and affordable, and whereas children need safe and loving environments to learn and grow while their parents work or attend school, and I'd like to yield to Representative Scott.
She will yield. Representative Scott.
Thank you, Mr. Chair. Whereas approximately 8,700 licensed family child care providers open their hearts and homes to Minnesota's children every day, offering an environment that meets the social, emotional, and cultural needs of the children and families they serve, and I'd like to yield to Representative Albright.
He will yield. Representative Albright.
Thank you, Mr. Speaker. Whereas Minnesota's licensed family child care providers are dedicated professionals who operate small businesses that provide an invaluable service that is integral to the economic growth and prosperity of our state and communities. And, Mr. Speaker, I would request yielding to Representative Quam.
He will yield. Representative Quam.
Whereas licensed child care providers make many personal sacrifices to provide the absolute best care to the Minnesota's children, offering an exceptional early education that prepares children for school and life. Now, therefore, and I yield to Representative Franson.
She will yield. Representative Franson.
Be it resolved by the Committee on Rules and Legislative Administration of the House of Representatives of the State of Minnesota that May 7th through 13th, 2017 be recognized as the Week of the Family Child Care Provider. We call on Minnesotans to honor family child care providers and thank them for the contributions they make to our children and our state.
The member from Hennepin, Representative Hortman.
Parliamentary inquiry, Mr. Speaker.
State your point of parliamentary inquiry.
Did you continue the calendar for the day or no?
We did not.
Okay, thank you, Mr. Speaker.
The member from Hennepin, Representative Pepin.
Thank you, Mr. Speaker and members. I move that when the House adjourns today, it adjourns until
12 noon, Monday, May 15th, 2017.
Mr. Speaker,
The member from Hennepin, Representative Hortman.
since I blew it under announcements, members, we will caucus on Monday at 11. We're coming in for session at 12. Is that right? Thank you.
Representative Pepin moves that when the House adjourns today, it adjourns until 12 o'clock noon on Monday, May 15th, 2017. All those in favor say aye. All those opposed, no. The motion prevails. Representative Pepin.
I move that the House do now adjourn.
Representative Pepin moves that the House do now adjourn. All those in favor say aye. All those opposed say no. The motion prevails, and the House stands adjourned until 12 o'clock noon on Monday, May 15th, 2017.